Welcome to the Expertise Unlocked podcast, a part of IR Global, the largest international professional services network. I'm your host, the podcast Jennifer Riggins. Today we're sitting down again with Michael Einbinder, founding partner of New York City-based business law firm Einbinder Dunn LLP, who, both him and his whole team have extensive experience both in representing clients and acting as an arbitrator. Definitely check out our 3 previous conversations in the same feed where you are, where we've spoken about the importance of documentation as a contingency plan for the whole business, which I believe is really cleverly named Get All Your Docs in a Row. We also talk about non-compete clauses, and we get in everything franchise law, from the tiny franchise org to a giant multinational to for being a franchisee. So today, Michael and I are talking about corporate divorce. Hi, Michael. Always a pleasure to catch up. For those that haven't listened to our conversations yet, please tell us a bit about yourself.
Good morning. Jennifer, as you know, my firm is based in New York City. We represent small and medium-sized businesses. We represent some individuals, but generally in business transactions, and some estate planning work and some work related to other personal issues, like relating to, say, guardianship or other things that might come under the rubric of personal representation. We also represent and mostly represent small and medium-sized businesses. Many of our clients are in the franchise field, and we have spoken about that in the past. But what we do for our franchise clients, we do for our general clients, our business clients generally. We represent clients in transactions, in mergers and acquisitions, in buying small businesses, in lease transactions, in corporate governance kinds of issues we talked about when we did Docs in a Row. We represent clients in dispute resolution. And that kind of dispute resolution is arbitration, litigation in court, or mediation, what's referred to as alternative dispute resolution. As you said, I am an arbitrator. I work with the American Arbitration Association. Through them, I get a number of cases where I act as an individual or part of a panel group of arbitrators where we hear and try cases. And a lot of everything that I do informs some other aspect of what I do. So when I am representing, say, a client in a corporate divorce, and we'll talk about what that means in a minute, what I bring to bear is that I've represented both sides in that kind of transaction or dispute. That is someone who's being asked to leave an entity, or who's being shut out by his shareholders, or someone accused of doing that. I do arbitrations involving these issues, and so what I hear about in those cases, I hear from both sides, and that kind of tells me what the issues are that I need to be concerned about when I'm providing advice and counsel to my clients about issues in this field. And that's one of the things I like about my practice, is that I have a wide variety of inputs, and I think I give better advice to clients because of those inputs.
So you know both sides of the story, because there's the saying in more traditional definition of divorce where there's 3 sides to every story. The individual sides, and then I guess what could be arbitrated, right?
Right. So the 3 sides, I mean, it is 3 sides for me. I represent both sides of transactions, and when I'm acting as an arbitrator, I see what it's like and what I would want to hear about or think is persuasive when someone's trying a case in front of me. And I've been doing that for about 12 or 13 years, and it's really had a major impact on the way I practice law. It's given me a chance to look at something from the perspective that a judge looks at it. And I think it's been terrific for me. And a lot of what we're going to talk about today comes from that world, from my involvement as an arbitrator in a number of cases involving disputes between shareholders or operating partners or partners generally. So that's our practice.
Yeah, I guess we as society know a bit more about regular divorce, marital divorce. What is corporate divorce?
Well, to start with, it's just as personal sometimes as a
Imagine.
tradition was.
Your business can
Uh,
be your baby.
exactly. And I kind of feel that way about my business. We've been in practice for several decades, and we feel like it's what I grew up with essentially in my career, and so we spent a lot of time, effort, in developing and building it. And that's what many small and medium-sized businesses have the same kind of experience, where they've spent a lifetime or many years building and developing their businesses, only to find out that for one reason or another, there's a dispute between the partners. I'm going to use the term partners loosely: co-shareholders, members of an operating company, or partners in a traditional partnership. It's the same thing. I mean, there are fights between people who, quote unquote, live together, who spend 8 hours a day in your business or so, and the result of that can sometimes be disagreements and tension, and sometimes that boils over into a fight, which boils over into a divorce, a separation of some kind, between the parties. And one of the things that I've spoken about, in with presentations that you and I have worked on together, or with interviews that you and I have worked on together, as well as in other presentations I've given out in the world generally, is that the best way to avoid, or at least mitigate, the problems associated with corporate divorce have something to do with being prepared for it. And being prepared for it means making sure your documents are in order, and that if it comes to a fight, you are protected, or at least the rules of the game, or that the I's are dotted and the T's are crossed when you get into that fight, which sometimes rules the day, when they're not properly, when the action by one shareholder against another is not in accordance with the agreement. So, in general, go ahead, Jen.
No, I was just thinking that kind of like a prenup,
Well,
these awkward situations that you don't want to talk about ahead of time. So I assume a lot of, at least I could see this in the tech startup space, people put it off.
well, absolutely, or people start their businesses without giving much thought to what the future may hold. Um, Examples may be how you. Well, we're getting a little ahead of ourselves, but examples may be how you value ownership stakes in a business, when and you may do that 20 years ago, and then you come to a fight now, and the valuation that you put on the business when you started it is not remotely related to what its
Oh,
value is today, and that has implications.
so
Um,
even if you created the documents, you didn't update them in 20 years.
Absolutely, it's
Oh,
critical to do that. It's
okay.
critical to look at it, and it's critical to do it, and it's critical. You can put some flexibility in the documents to start with, but oftentimes you don't, or you don't follow through, or you take it out of a drawer when you need to 20 years later, and you find out it's curled up, it's on paper, it's not on a computer, you can't find it sometimes, or no one's looked at it or changed it in those 20 years, even though the agreement required you to do that. So let me back up a little bit. Let me talk about what this is. Um, my involvement in these kinds of issues, both as an advocate and as an arbitrator, stem from a disagreement between the partners of a business in how they're running the business, how one partner is acting vis-a-vis the business. And that may be that someone accuses one of their partners of self-dealing or stealing or anything, that brings a fight about. And a set of partners, a group of partners, tries to marginalize or box out one of their partners in some way that that is results in the partner who is being set aside essentially as a fight by that person to get back what they're entitled to or get back to where they were before, or in some cases to sue or take legal action of some kind against the two or three or four partners that are taking action against him or her to get money, get their value out of the business, what they think the value is. It may result in a death. So, there may be a death in the shareholders, and one of the four shareholders may die, and the question of what the valuation of that person's share is for the purposes of dealing with his or her estate may come into play, and that's a matter of something that you can address in documentation. So, the fights come in a wide variety of colors, if you will. I've been involved I've represented clients where they're accused of taking action that's unfair action, or what's called in the law oppressive action against one of their partners. I've been involved in cases in which one of the partners has stopped being actively involved in the business, and family members end up fighting about how the company is being run, or one wanting to sell the business and the other wanting to stay in the business and continue to have an income stream from the business. And then the question of what the value of the business is comes up. I've seen situations where controlling shareholders have discharged partners who were employees of the company, like an officer of the company, under either fair or unfair circumstances, where there's a fight over whether or not the termination of the officer's agreement is somehow a violation of the agreement. And so when I talk about the documents that are necessary to at least mitigate the problem, it's really a question of having flexibility in them or updating them on an ongoing basis, so that hopefully the issues that come up in litigation that relate to the parties' agreements are at least being addressed as much as they can be when you enter into the agreement or when you update it from year to year.
Okay, so annual update, what agreements do you need?
Well, listen, a corporation has a shareholders agreement, or should have a shareholders agreement. And quite honestly, we have plenty of clients out there who don't do their shareholders agreements, or they get it off of LegalZoom or something, and it's very, very, very basic. And because the most important business of a business is to make sure it survives and then build it, they're not thinking about the legal documentation, and they're not thinking about the fight, because it's all great in the beginning. Hard, but it's you're building together something.
Yeah.
Sometimes what happens is there's a lot of money at stake. That you didn't think was at stake when you got in there in the first place, and now there's a fight over how you deal with that, how you divide that, whether or not the business is worth, whether or not one shareholder wants to sell it and the others don't, because he wants to cash out. There's all sorts of reasons for a fight, but the documentation is really important. So the documentation for a corporation is a shareholder agreement. The documentation for a limited liability company is an operating agreement, and the agreement for a partnership is a partnership agreement or joint venture agreement. All of those agreements can and should be updated. Especially the new one that you started with, the first document you signed. Frequently they get updated when new shareholders come in or new owners come in. It's not necessarily a yearly thing, but it's worth showing your lawyer or advisor what you have, or looking at it yourself and saying, oh my God, this business is not the same as it used to be. Or there's 3 people who signed a shareholder agreement, and we brought in 2 new partners, but nobody bothered to have them added to the agreement. And now we don't know what the percentage interests are. And so those things come up all the time. And so our advice is get your documents in order and take a look at them and see if they need to be updated. But here I want to talk about, the fight itself, or what you have to worry about.
When you don't have your documents updated as
right.
well as you should.
Or when you do or you don't.
Yeah.
But then you have to fight or address problems with what you have. I'm just saying that it's often older documents that often create more trouble than you really should have to deal with.
Hmm.
Um, and sometimes can alleviate some of the problems or even eliminate the problems. And I mean, just a quick example of an old document that came back to haunt somebody is I was involved in a case involving quite a number of an agreement that was entered into 20 or 25 years before an event that occurred where one of the partners needed to be bought out. And the provisions in the agreement provided that if there was a buyout, it would be at an agreed upon valuation that was done when the partners entered into their shareholder agreement.
Oh, so it didn't say at the time of separation
No.
what the valuation is. It just said an exact number of what it
Yeah.
was.
Right.
Value moment. Oh.
And the result of that was completely unfair to the person, in my view, who wanted to get out or had to get out, and had to be bought out. And the agreement itself provided that there was a valuation of, say, $25,000, and it provided that would be updated every year.
Okay. So
It
it
never
said
got up.
in the agreement that it had to be.
Yes, it never
Okay.
got updated.
So who's at fault in that situation? Weren't they
All of them.
all?
Yeah, everybody. I mean, I don't know if maybe they didn't agree. That didn't actually come out in the case that I was involved in. It wasn't.
Yeah, it
And
did.
the business was probably worth $4 million when they split up. And so a quarter share of that was $1 million, not 25 grand. And the better version of that agreement would be to say that it goes up X% every year, or it's based on something, or it'll be valued at the time, or something. But this one had a static value. And so, it was an arbitration. I was the arbitrator, and you're stuck with it.
Oh, okay. So it's not for the law or the arbitrator in the situation's decision to decide what's fair. It's what's written.
Right. I mean, I'm not there to decide what's fair. My job is to look at the documents and make sure that that the fight was proper, that they dotted their I's and crossed their T's, as I said before, and that they and what the value of it was. And the party who wanted the higher value said, well, the business is worth a lot more. And I said, well, okay, but here's what the agreement says. And I don't get a choice. I just have to follow the law and the facts. So I did what I had to do. So that kind of issue has come up in my cases. In a case involving three partners of a business entity, that was where one of the partners was brought in 2 years before the fight, and the business that he was brought into was 20 years old. The two main shareholders, the first two shareholders, felt that they that the new partner was not doing his job, and they wanted to get rid of him. They wanted to buy him out. And then when that started percolating as an issue internally, that shareholder started a case against the company, or against the two other shareholders, seeking trying to prove that they were oppressive shareholders, that they were doing something unfair to him, that they were dealing behind his back, that they weren't following the dictates of the shareholders agreements. And so the fight ensued over whether or not my clients were being oppressive, a term that's used in New York law, and also used, say, in New Jersey, where this company was located. And the fight was around that, and whether or not it was appropriate or fair for one of the shareholders, or the two shareholders, the two majority shareholders, they had 2/3 of the business, to try and market the company for sale without informing the third guy that it was being marketed for sale. And whether what they did was really marketing it for sale or just having a preliminary conversation with someone. And it can take any form, So that was the fight. And so, we have agreements where there are three shareholders and two of them have 2/3 of the ownership stake. That gives them some control, but it's not unlimited. And by the way, not for nothing, but that's a creature of the state law, of the state where you're operating, because the law in the US, as my friends overseas always are shocked to find out, or frequently shocked to find out, is different from state to state.
Wildly so, yes.
Yeah, and it's complicated, and what law applies is sometimes complicated. So, if you form in certain states, minority shareholders have less rights. If you form in certain states, they have more rights. So that's an issue.
And lawyers have to be accredited by passing the bar in each different state?
No. I mean, you have to be accredited to be a lawyer, to act as a lawyer for someone in every state. But when you're, when I'm in a trial in New York where I'm admitted to the bar, if the law involved is, say, Delaware law, a popular place to form entities, companies, LLCs, and corporations, I can analyze the law in another state. That's straightforward enough. I mean, maybe that someone in Delaware has more experience with that than I do, but it's not that complicated. The question of minority rights is something that's pretty well defined under laws of various states. So that happens. That's an example of something that might happen. Other case. Jen, go ahead. Why don't you ask me the question? I keep going
No,
without.
Just I want to know if we've gone through the get ready, be prepared. It's better to be prepared ahead than to go through this now. But so if you're going through this divorcing process, what are steps that you cannot miss in this process? What are important? How does this process usually take place?
Well, I mean, the fight itself before me is sort of baked in. What has been done is baked in when I get the case. So they've already taken actions, whether they've done them properly or not, or they're allowed to have done them, is a question that I have to address as an advocate or decide as an arbitrator. And an example might be this. Shareholders agreement generally provides that in order to have a shareholders meeting or a board of directors meeting, you have to give notice. It either has to be an annual meeting set on a specific date, or it has to be what's called a special meeting. And a special meeting, this is New York, and this law is not different, substantially different in other places, but I'm giving you an example of New York law. In order to have that meeting, a special meeting, you have to notify all shareholders that it's happening, time, place, and purpose. Okay. So let's say two shareholders get together, or 3 or 5 or 7 or whatever it is, and they want to get rid of somebody because she's doing something that they think is improper. If they take action at a shareholders meeting without notifying her and discharge that person and take a vote that they can buy that person out, let's say that's authorized under the agreement, it's an invalid meeting. It didn't happen legally because they didn't give notice.
What if they, I don't know, make all these decisions? Okay, context. We've just been binging the morning show. So a lot of this is in my head on Apple TV, maybe in the media area, but there's a lot of board meetings. There's a lot of behind the scenes stuff. But if they have that external meeting, unofficial meeting,
The special meeting that isn't done right.
a special meeting, but without the main person there, and then they have an official meeting with that person there, but they've kind of already made this decision. They just go through the formality. Is that okay? Or are these conversations not okay without everyone there?
Well, listen, if the case, I think that when they do the meeting improperly, they don't. Let me put it a different way. I haven't started putting it anyway, so let me put it away. Let me explain it. I have never come across a case where a special shareholders meeting was organized without telling the person that was impacted by the meeting, where before the case started, corrective action was taken to redo it the right way.
Oh,
And sometimes the fights,
that corrective actions available?
yeah, I've never seen it. I suppose if you find out months later, the damage is kind of already done. I mean, I was involved in one case as an arbitrator where this was done, and you know that case was a claim that the action taken improperly was an oppressive action, um, and I think it was, I should say, and then the rest of the case was mostly about slinging mud at each other, about the various things and trying to prove or disprove that the things for which the party left out of the meeting was guilty or not guilty. But putting that aside for a minute, it was like trying to make a determination about whether or not the actions that resulted in the shareholders meeting vote that was improper had actually happened or not. And that's a reasonable thing to fight about, right? Because if the reason they threw this person out is because he stole money, let's say, that's not the case in my case that I dealt with, but let's say someone accused her of stealing money. And it turns out that that person didn't steal money, then the whole thing falls because the rationale behind the dismissal or discharge is not valid. And so even if the meeting was held in the proper way, an arbitrator could rule or a judge could rule that the termination of employment was improper, or the termination of the relationship was improper, and the buyout was improper, or the demand for a buyout. But the first thing you decide is whether or not the action itself, the dismissal or the discharge or the exercise of a right to require a buyout of the third party at a reduced price because she was fired for cause or something, is the first order of business is to find out if the meeting was legitimate. And if the meeting wasn't legitimate, the whole thing fails. Then the guy or woman who got thrown out has a case, say, for oppressive action by the shareholders, which gives him a right to be, or her a right to be bought out. And then the case is about valuation, which is a whole other story, because valuing a business is, I think, more art than science. There are a wide variety of ways to do valuations, and a wide variety of metrics that go into determining value that you do fight about, and that I, as an arbitrator, have to decide, and as a litigator or an advocate in arbitration or court has to prove or try to prove.
Because that
So,
was in the documentation up to date. Because
well, I
otherwise,
mean, the document up to date evaluation. I mean, the case that I told you about where someone was was entitled to be bought out, but the valuation was stuck in 1997. It is one bad example of not keep updating the documents. But oftentimes it says at the then fair market value or fair value, or
that's what would normally be on there,
you'd think
especially
so.
it's subjective. It's definitely somewhat subjective. Look in the
Well,
world of tech, what a unicorn, are they actually anywhere near that value?
I mean, the value, if either it's defined specifically to say fair value or fair market value, there are different definitions of those things. There are enormous amount of inputs into deciding what the value is. So it starts with how much the value of the assets are. Maybe it starts with the value or the revenue or profitability or EBITDA, which is earnings before taxes, depreciation, and interest, and amortization. Those things are the first order of business to find out what the basis of evaluation of a particular type of business is. So there are sort of mark analyses of how certain businesses are valued. It may be revenue based, it may be profit based, it may be EBITDA based. It's always comparable to the market. What are people valuing a tech company at? What are the accountants valuing a company that purely gets revenues from license fees or royalties? What are the different valuations? And then the multiple, right? So you look at the EBITDA, maybe you multiply it by 3, 5, or 7. And then, and then you have to figure out in the context of all of this, what it actually was. And because that's sometimes a fight. Because say, for example, you're in a company where the president of the company gets a really expensive car every year, leasing a car. That's a shareholder, that's a specific analysis that's done in these things where it's discretionary spending by the corporation for something that really is taken out of the mix. So if you're spending $15,000 a year on a car, I'm just making up numbers, on personal things, then you take that out of the expense associated with the business, and it increases the value of the business. You do an analysis called normalization, where you take out and add into certain things, certain aspects of the financial documents or financial analysis to make a decision about what the profit actually is or what the EBITDA is. And then you fight about that if you're on both sides. Well, you should take this out too. What about that really expensive health insurance policy? Should that be taken out or added back? All sorts of stuff gets thrown into this blender to analyze the valuation. And then there are issues about whether or not minority shareholder value should be less. Non-control is valued less than control. Because being a 30% shareholder of something doesn't give you any right to much of anything in terms of the governance of the company, if there's a guy who owns 70%. So the valuation of that person's interest at 30% is going to be substantially different than if it was 50%. The valuation of the company for the purposes of this. So if you own 60%, let's say the company's worth $1 million, and you've got 30%, then you would say, well, my value is 30% of that. But that may not be true, because the valuation, there may be a discount for non-control. So
also, it has nothing to do with the value of the work you have done for the company.
Well, not really. It's usually the value of the company. I mean, It may be if you're also an office, if you're salaried, or you were supposed to get X dollars a year, and you're fired improperly from your own business, then there's an issue there. So the thing that we look at as lawyers, whether I'm acting as an advocate or an arbitrator, and that I expect to hear as an arbitrator, is what steps were taken to in the fight. It was a shareholders meeting held. Was it properly held? Was the vote proper? Was notice given? All those things come into play. Were they allowed to take that action under the shareholders agreement or under law? What happens next? A long time ago, one of the first times I did this, and really gave me a real interest in this, I was involved in a case, and this goes back to the early part of my career, where a shareholder with a small stake in the business, but a significant job in the business, was fired for cause, which gave the majority shareholders the right to buy her out. And so in order to determine whether this was all done properly, we had to look at the employment agreement, and then we had to look at the bylaws of the company to see if the votes were taken in accordance with bylaws, and then we had to look at the shareholders agreement to see if it was compliant with that, and then we had to look at the valuation section to make all this decision. It was this sort of tree that we had to grow, if you will. I don't know, maybe a lousy analogy, but metaphor. But it was really interesting to me, because it was It was all these laws or all these agreements that informed the entirety of the case and could fall or succeed depending on whether or not the first, second, or third steps were right. So she argued, this employee argued that she was improperly terminated. The valuation of her share, so she could be terminated for cause or not for cause, or for no cause. And if she was terminated for cause, then her values, the value of her interest or the value of the buyout would be way down. And if she was,
Depending on the
right,
cause, I guess.
if she's terminated for cause, for not for cause, I'm sorry, well, yeah, not for cause. If the claim was made up or it was just wrong or the facts weren't there to support it, then her termination was not for cause and the value shot up.
Mhm.
You have to look at all these things, and you should have in your agreements all those things. But if you've listened to me talk about this a couple of times, you realize that if the agreements don't match each other, right, the same terminology, the same issues, and I've seen where they don't, then it's a mess. But in this instance, it wasn't. It was an employment agreement that said if you get fired for cause, we can buy you out, and if you get fired without cause, we can buy you out. Then you have to figure out what the valuation is. And then you have to do the whole other analysis that I described a couple of minutes ago.
So this would be, yeah, impossible for anyone to do on their own. Even if they were, I don't know, have any sort of think they have knowledge or friends, etc. You just need to, from the start of your company or your partnership or your joint everything, you really have to have that documentation in order, but you have to force yourself, schedule, put it even on Google Calendar for repeat every year, where you have to re-examine these documents every year. And there's no way you could do this on your own. You would have to have a lawyer or an arbitrator involved, because
In the fight, right.
the fight, and I guess in setting up the documentation from the
Well, the
start.
lawyer should do that from the get-go, and it should be updated. And I don't know if every year isn't necessary, but it's certainly something that you should look at if you haven't done it in a while. And a while, I'm not going to define that. I mean, if clients came to me and said, how often do you want to do it? I'd probably say, look at it every 5 years and let's talk about it. Or where there's a major change in the way the business operates, or new partners, or major increase in revenue. Any number of really kind of material things happening in the business kind of dictates what you do and when you do it. If there's a fight, there's a whole host of people who were involved in it, because I can analyze whether, if I'm an advocate, analyze whether or not the shareholder was terminated properly. In the example I just gave, the employee was terminated properly. I can analyze what the impact of that is on valuation, in the sense of maybe it's about the multiple. If you're terminated for cause, your multiple is 3. If you're terminated without cause, it's 7. I don't remember what's in this agreement, but it could be it's a different valuation, or maybe it's a buyout, a very cheap buyout if you're terminated for cause. Whatever it is, I can value all of that. I can look at all of that, and I can advocate for somebody with all of that. And if I'm an arbitrator, I can decide if it was done right. What I can't do is, as an advocate or as an arbitrator, is do the valuation myself.
Okay.
Or I don't. I don't want to, because there are too many competing factors involved. And so in every case I've ever been involved in, from any side, from any of the 3 sides that I work on, the person who started the process, the person who's gotten hurt allegedly by the process, or an arbitrator deciding it, I'm listening to experts tell me what the story is. And you're not going to be surprised, or certainly I'm not, that they're not going to agree. And so in the cases that I've done, I've frequently heard 2 and maybe more experts testify about what the valuation is.
Hmm. I'd hope so.
Yeah. I think it does, and there are cases in which there's a question of what we're valuing, also, to just make it more complicated. Are you valuing the assets of the business, or are you valuing the profitability of the business, to do the multiple analysis? And that's depends on which side you're on, right? Maybe the assets are an apartment building in New York, but the profitability is low and the value of the apartment building is much bigger than you'd get to otherwise. It depends. And so you have an expert come in and say, this is what all these values are, and then the arbitrator gets to decide, or a judge gets to decide which of the valuations that are put in front of them. It's
Have
complicated.
valuation partners been part of IR Global, or you've met through the network?
Oh, absolutely. There are a lot of people that I've met over the last 5 years or so, or 6 years that I've been in IR Global, that do exactly these things. And sometimes they specialize in particular industries. Sometimes they're industry agnostic. They're happy to do it just based on numbers. But there's a lot of research available to accountants or people who do valuations generally, to come up with an analysis of it and to advocate for it. But it's not like I've ever come into a case from any perspective and the two sides have agreed that the value is a certain amount of money, and they're fighting over whether or not one party has to buy out the other. There are different ways to look at it. That's why I said it's more art than science. And if it was simple, it would be a lot. If it was simple to value these cases, it would be a lot more simple. But it's not.
Value can change from day to day as well.
Yeah, exactly. Well, that, not for nothing. Again, you have to pick a valuation date.
Yeah.
So what's the valuation date? Is it the date the guy was fired, or is it the date they're in court? Or is it the end of the year or the first? I don't know. It's everything. It's just that's the point. I mean, the point of this is, I can tell you where the fight. I can tell you how you can address what might be a fight in advance, to the extent that you can, by cleaning up your documents and making them make sense. I can address how you go about the fight itself before you get to the arbitrator or judge. Client comes to me and say, listen, I have a problem with this new person we brought into the business. What do we do about it? And I'll look at the shareholders agreement and everything else in the law and see, this is what you can do and this is what you can't do, and then take legal action to do it. And maybe an application or an effort to dissolve the company, or to ask a judge or arbitrator to force a buyout.
Okay.
There's a lot of different variables.
Yeah, certainly there are, in this situation, it seems like you need to know the questions to ask as much as you know the answers, because the answers could vary anyway. So if our listeners want to get in touch with you to, pick your brain more, ask about specifics, because it sounds all very specific or context specific and paperwork specific, how do they get in touch with you, Michael?
Well, my email is probably the best way to reach out to me, because I'm looking at email more than I should. So I will respond. My email address is my initials, me@ed-lawfirm.com. And my website is ed-lawfirm.com. And you can reach out to me by phone at my office in New York, which is 212-391-9500.
Very good. Look at you knowing your own phone number. That's it's a talent unto itself these days. Thank you so much, Michael, and thank you, listeners. These Expertise Unlocked podcast episodes are meant to be educational resources from experienced lawyers, accountants, and financial advisors, trusted advisors with extensive knowledge on topics you as professionals need to know about at all aspects of your journey. To learn more about IR Global, please visit irglobal.com. And if you found this episode useful, or you know somebody that may be contemplating corporate divorce, please consider sharing it. Thanks, y'all.